Good afternoon, everyone, and welcome to today's HR Advice webinar, which is addressing the rise, navigating spikes in sexual harassment cases. I'm joined today by some very special guests from Advisor Plus to share their expertise on the impact of sexual harassment in the workplace. So that goes for both employers and employees. And today they're going to be getting into the practicalities on what you can be doing to prevent this in the workplace, with loads of great advice included as always. So my name's Alice and I work at Sage as a learning facilitator, delivering webinars and other video content too. I do work on a variety of products, but you'll probably have seen me before if you've been to any of the webinars on Sage 50 Payroll, Sage HR, or even some of the previous Advisor Plus sessions too. But yeah, Sarah, do you want to go and introduce yourself?
Yeah, thanks, Alice. So my name's Sarah, and I've worked in HR for the last 10 years, prior to which I worked as a solicitor dealing with employment tribunal and civil litigation disputes. I've worked within several sectors, including healthcare, insurance, retail, banking, and facilities management. And my role at Advisor Plus involves supporting the advisory team with complex and high-risk cases, and a big focus on upskilling and training as well. I also undertake consultancy work on behalf of clients, including acting as an independent hearing manager and consultant, supporting businesses through change processes, and also supporting businesses with improvements to their own policies and procedures. And I'll hand you over to my colleague Katie.
Hello, I'm Katie. I've worked in HR and employment law now for 25 years. I've been an advisor with Advisor Plus for 3 years, supporting customers with their ER issues and coaching managers. Before this, I've worked in firms of solicitors in private practice, in-house for companies and consultancies, as a litigator representing mostly employers, but also employee clients in things like employment tribunals, mediations, arbitrations, at early conciliation, and then at the Employment Appeal Tribunal. I've also provided general employment dispute advice, consultancy, training, mock tribunals and legal updates.
Great, thank you both of you there. Yeah, so that's who we are. And I did briefly mention what the plan is today, but just a little bit of an idea of what the experts will be focusing on and what we're covering in the session today. So we will be covering what is sexual harassment, what your legal duty is to prevent sexual harassment in the workplace, why it's so important to stop it from happening, what proactive steps you can take to prevent it, and then also what to do if you do get a report of sexual harassment in the workplace and the kind of steps to carry out there. Now, as always, we do have the slides available, as I said, via that handout icon. And later today, we will also be sharing a follow-up email with a full recording of the session today, so you can re-watch that if you need to, or if you want to share it with any colleagues as well, you will absolutely be able to do so. But without further ado, let's get going with the content today. So first thing we're going to cover is what is sexual harassment. So Sarah, for those of the people attending today who might not have come across this in the workplace, can you just talk us through a little bit about what it is?
Absolutely. So the legal definition of sexual harassment can be described as unwanted conduct of a sexual nature which violates their dignity or creates an environment that is intimidating, hostile, degrading, or humiliating or offensive to somebody. Now, that's quite a broad definition. So if we think about it in certain ways, some examples of sexual harassment could include, but aren't limited to, things like unwelcome sexual advances, touching, sexual assault, sexual jokes, asking somebody about their sex life, or sending emails with materials of sexual nature. And it's always really important to remember that it can still amount to sexual harassment even where the recipient didn't complain, they didn't ask them to stop, they appeared to laugh it off, or the behaviour wasn't directed at them, but someone else in the environment, and they were just a witness to that incident. Although I'd probably say post-COVID, we're seeing a lot more people now returning to office and site-based working. We've still got a lot of people who are still working remotely or on a hybrid basis. As such, it's really important for businesses to understand that sexual harassment can also take place remotely, such as in the form of things like texting, emails, and Teams messages. We're getting a lot more of an attention in that within the legal sphere as well. For example, in 2024, we saw the first criminal conviction for cyber flashing, which goes to demonstrate that varied and diverse working world that we're now operating in. Within that definition, it's also really important to note that harassment is judged from the employee's perspective and how the behaviour made them feel. What one worker, or even a majority of workers, might see as harmless fun or banter, another may find unacceptable. To give some further context to this, a good few years ago, before sexual harassment appeared to become on the rise, there was a 2020 government survey which found that staring and unwanted sexual jokes were the most common forms of sexual harassment. And that's probably not what comes to mind for most people when they think of sexual harassment, but it is just as harmful. Ultimately, if the behaviour has one of these effects, even if it wasn't intended, it can still be classed as sexual harassment.
Just on mute. Thank you for that, Sarah. Katie, I did also want to talk about the kind of impact on employees as well. It's bound to have an impact on them. What type of impact can can sexual harassment have on them?
Thank you. Yeah, it's fair to say that when incidents of sexual harassment occur, the impact on employees can be considerable. So firstly, it can have a direct impact on an employee's mental health and their well-being, and then have a consequential impact on things like their attendance at work, their productivity, the quality of work, their loyalty, and then the commitment to the business as a whole. However, it is important that we remember that every colleague is an individual and that the support that they will need and require after experiencing an incident of sexual harassment will vary considerably. As we are only all too aware, although a report of sexual harassment in the workplace should be treated with confidentiality and sensitivity by an employee may talk about what's happened to them to other colleagues to seek their support, their guidance, and their reassurance. As a result, harassment cases can impact the morale of the team and of the business's reputation outside of the immediately affected employees to a much wider audience. On a positive note, an employee who is supported by their employer and a cohort of employees who see action being taken can really appreciate the response of the business they work for, and they can feel protected and valued. So there are huge positives in getting your approach to sexual harassment right. At the far end of the scale, if the knowledge of a claim gets into the public domain or the press, the reputational damage or embarrassment can have an impact on a much wider group of employees and even clients of the business. For example, during an appearance before a select committee in January of this year, in response to concerns raised in the media about multiple reports of sexual harassment across multiple food outlets, the CEO of McDonald's advised that 29 people had been dismissed in that business alone in the last 12 months as a result of sexual harassment allegations. So we're yet to see the full impact of these kinds of reports, but it may yet harm their ability to employ the right people to lead their business and detrimentally impact the number of people who interact with their business as a whole.
Yeah, no, you're absolutely right. And I think it does seem that we're seeing more and more reports of sexual harassment, a lot more in the press too. So it's kind of considering why this is and what duties do employers have to prevent it in the workplace. Sarah, do you have any thoughts on this?
Yeah, absolutely. So back in October 2024, the government brought in a new piece of legislation, which you may have heard of and is known as the Worker Protection Act 2023. What this does is this provides additional protections to individuals in the workplace, alongside the ongoing provisions of the Equality Act, which seek to prevent discrimination, victimisation and harassment in the workplace. This new legislation requires employees to demonstrate and/or evidence that they are taking reasonable steps to prevent sexual harassment in the workplace. This is a really big step in employment legislation, and it places a significant proactive duty on employers to protect their employees. Just as by way of a bit of background, this piece of legislation, which was introduced before the current Labour government came into power, received a lot of cross-party support as a result of some extensive research from the Government Equalities Office back in 2020. And in terms of some of the highlights from that report, this stated that 72% of the UK population has experienced at least one form of sexual harassment in their lifetime, and 43% had experienced at least one sexual harassment behaviour in the last 12 months alone. Even more striking, 29% of those individuals experienced sexual harassment behaviour at work in the last 12 months. These figures show that the spike in sexual harassment cases isn't just a statistic. It's impacting people on a daily basis and has been clearly causing issues in the workplace for too long. It's really important that we now act swiftly to prevent sexual harassment, to protect employees from this behaviour and comply with this legislative duty. It's also really important here to remember that sexual harassment can apply to anyone, regardless of their gender, by which they identify, their sexuality, or their age. For example, there was a recent YouGov survey which found that employees aged 18 to 24 would be less likely to report allegations of sexual harassment than their older peers. Just because you don't have any cases of sexual harassment being reported, what this shows is that it doesn't mean it's not happening. And as such, it's imperative that you comply with this duty to make sure that you are protecting your workforce, regardless of the size of your business or the demographics of your workforce. Under this new legislation, employers are also responsible for any harassment directed at their staff from third parties, unless they can show that they've taken those reasonable steps that we mentioned earlier to prevent it. So on top of your current duty, you'll also need to be thinking about how you protect your employees from harassment from clients, customers, and third parties. And linking into that earlier definition of sexual harassment, that can be face-to-face, it can be online, it can be via the telephone. We're looking at all interactions here. Going forward as well, we've also got the Employment Rights Bill on the horizon, which you might have heard a little bit about in our previous webinars as well. Under this proposed legislation, this current duty to take reasonable steps is going to become even stricter, with employees being required to take all reasonable steps to prevent sexual harassment at work. This means that the bar to defending a claim of sexual harassment in the employment tribunals is going to escalate even higher. A complaint of sexual harassment will also class as a protected disclosure under whistleblowing legislation. In the last couple of weeks, the government have published their roadmap for this proposed legislation, and although this higher duty is unlikely to come into force before October 2026, it's important to start thinking about this now to make sure that your preventative actions in the workplace are watertight.
100%. Thank you, Sarah. I feel like that really demonstrates that we need to act to stop sexual harassment in the workplace. Really, really important to be informed of these employer duties too, especially with those upcoming changes. Moving on to the consequences of not complying. Katie, what are the risks for an employer?
Yes, thank you very much. Absolutely. So other than the impact on the well-being of individuals that we spoke about earlier, both physical and mental, there's also the financial and reputational risk of the employee bringing an employment tribunal claim. As of the end of March 2025, there were 45,000 ongoing ET claims, a 32% increase on the previous year. Although it's really difficult to ascertain how many of these are related to sexual harassment, or even how many of these claims will eventually be successful, it is fair to say that a significant number of these claims will involve allegations of sexual harassment. To add some extra context to this, within our client base here at Advisor Plus, roughly 1 in 7 of the grievances that we deal with are related to sexual harassment. This equates to 15%, and we're seeing this rise year on year. If a similar pattern is occurring in the employment tribunals, it's a worrying rise in the number of cases that they will be dealing with in the near future. Alongside the legal costs of defending any claims, compensation for harassment is uncapped, and the amount of compensation awarded to an employee will depend on their perceived loss, including the severity of the injury to their feelings. An employment tribunal will have regard to various other factors, including but not limited the sensitivity of the claimant to the employer's conduct, stress, medical conditions, and the impact of discrimination on the claimant's career. In addition to this, following the new legislation, an employment tribunal can increase the compensation awarded to an individual by up to a further 25% if it finds that that employer has failed to comply with their legal duty to prevent the sexual harassment in the first place. Since the October changes, we're yet to see the latest draft of case law come through to demonstrate how the tribunals are going to exercise these new powers. However, prior to the legislation changes, we saw one of the biggest claims against a city company to date. In this claim, an employee was found to have been subject to lewd comments, including, "I bet you like to be on top in bed," and being told to take a more submissive role, which saw the employee awarded £1.3 million in compensation for her claims. Now, if that claim had reached the tribunal today, then regardless of the impact of inflation on any compensation, the tribunal could have awarded that claimant a further £325,000 in compensation, which is a pretty hefty increase. In addition to this, the action against an employer doesn't stop at the doors to the tribunal. The Equality and Human Rights Commission will also have the power to take enforcement action against employers who don't do enough to make that preventative action, which could include conducting their own investigations and entering into binding agreements with the employer to ensure that they do address that issue. Could even go further and take regulatory actions against businesses.
Yeah, definitely. So we are looking at some pretty significant consequences then for not being able to demonstrate that you've taken, the reasonable steps to prevent this. Even if a business hasn't yet taken the steps to prevent sexual harassment, from the figures that you've mentioned, it's never really too late to start. So if a business hasn't got any measures in place as of yet, what can they do from today?
So as a first port of call, employers should review all of their policies to make sure that they're all up to date and that they're detailed enough and that they've been brought to the attention of all employees, along with the consequences of not complying with them. Whilst a policy should be succinct, it should also be detailed enough to set out what actions an employee can take, how they will be protected in bringing any concerns to the attention of the business, and who they can approach within that business for help. You might want to consider having a separate policy for sexual harassment so that this is an easy thing for your employees to understand and utilise if needed. If you have a lot of employees, for example, whose first language isn't English, you might want them to have translated versions of these policies available to them. You should also make sure that they're accessible to anybody with disabilities. The policies should clearly signpost your employees as to where and how to report those incidents of sexual harassment. This could either be to their line manager, to a trusted individual or representative within the business, or via a reporting process online within your own secure intranet. Either way, it's everybody's responsibility to report sexual harassment and escalate it to management so that it can be dealt with really swiftly. When looking at your policies, you might also want to consider putting a risk assessment in place. Whilst every business is different, you might need to make sure that you're considering the potential for sexual harassment to occur in every kind of environment. For example, if a lot of your employees work remotely or on a hybrid basis, you might want to update your social media policy or electronic device policies to make sure that these prevent that sexual harassment in the first place. Then to embed those policies into the workplace, you might want to consider posters that are regularly refreshed, for example, in shared areas, so that the message remains current and relevant. Then at the other end of the spectrum, your business might be involved with a lot of events, for example, where they're not on their main site of employment. This could include marketing or social events where alcohol can be consumed. These can be seen as high-risk events, and you should make sure that a report and support facility is available to everybody in those situations. For example, you might want to have a buddy system in place so that two individuals are paired together and they're equally responsible then for making sure that each other gets home safe. Training should then also be updated and rolled out to staff on a regular basis. If you are relying on delivering training that was set out many years ago, this would usually not be sufficient to defend a claim in an employment tribunal. It's really important, therefore, that the training is relevant and contains the most up-to-date information on sexual harassment. You should also keep a record of when your employees have undertaken it so that it can be refreshed regularly. We don't expect employees, of course, to have a detailed appreciation of all of the nuances of all of the different types of claims that can be made, but it is fair to make them broadly aware of the potential for personal liability they could incur, as well as the consequences for them individually, such as being disciplined or losing their job, and direct them towards when they can get further information or where they can get it if they don't understand or if they just want further guidance.
Absolutely, Katie. They're really important points for everyone to consider going forward. And it's also really important that this training is rolled out to all employees. As we mentioned earlier, no one is exempt from sexual harassment and anyone can be subject to it. Also, an employee's understanding of what can amount to discrimination or harassment can be full of gaps or incorrect assumptions, and a good training session can help to fill this. If you're doing, for example, this training in person, you could try and include some real-life examples where you can to try and make this relevant to your team. You could put together some pretend examples based on some of the things we've discussed today as a knowledge check exercise and ask the team, does this situation amount to sexual harassment? For example, if we took a scenario where you've got 6 admin assistants in your office team, and you've got Steve, who is giving Lucy a lot of attention, and although she's new to role, she feels it's too much and it's not needed. For example, Lucy tells you that Steve is often leaning over her shoulder while she's trying to type on her computer. Sometimes he even sits on her desk while she's trying to do her work. Lucy feels that he is invading her personal space and makes her feel intimidated and humiliated by the difference in treatment towards her. So is this sexual harassment? Have a think about that definition that we discussed earlier in the webinar and see what you think. And maybe you can take some similar examples back to your team. As an alternative, you can also use some real-life examples of case law to bring the risks of dangers of sexual harassment to life. We can obviously mention some of the case law examples that Katie mentioned earlier, and there's another really good example of a recent case where a male chef successfully claimed sexual harassment after his male boss repeatedly made sexualized gestures and sang the Victoria Wood song, The Ballad of Barry and Frida. You may not know the lyrics to that song, but within there he put specific emphasis on the repeated words, "Let's do it." This is perhaps less blatant than some of our earlier examples, for example, when someone's been physically touched inappropriately, but it demonstrates that the definition of sexual harassment is really wide and is based on the perceptions of the person who is subjected to the behaviour in question. In the alternative, if you've got individuals who are completing online training, you might want to follow this up with, say, an interactive discussions within your Teams meetings, where people can share what they have learned in a secure environment. You might also want to consider doing some mock discussions with a concerned employee, where managers alternate the role of the employee and the manager so that they can understand how they might feel when raising concerns. This will really help to make sure that you're putting forward a zero tolerance message on sexual harassment and that becomes embedded in your business and helps to improve your workplace culture as a whole.
Thank you, Sarah. Now, if an employer does get a report of sexual harassment, what should they do from there?
Thank you. That's a great question. Firstly, it's really important that you think ahead and prepare your managers in readiness for a potential report of sexual harassment. In addition to the training we mentioned earlier for all employees, you might want to consider specific training for your managers. This might include training on how they can identify sexual harassment in the first place, and even if things are not directly reported to them, how to spot those signs. For example, has an individual's demeanour changed? Are they off sick more? Are they avoiding certain individuals or certain work tasks? If your managers are in that situation, it's important to know how they should approach an individual sensitively and confidently. So you should let the individual know that you're concerned about their well-being because of the changes you've noticed in the workplace, and ask them if there is anything they want to share or discuss. If you have mental health first aiders in the business, for example, you might want to involve them in this training and seek their support in the circumstances. It might be that during those discussions, an individual might not reference sexual harassment in an explicit way. So try and understand the situation as a whole and ask questions such as who, what, where, there, and how. This will help you get a good understanding of what's happened at the outset and understand what further evidence you might need to obtain to verify those allegations, such as witness statements or CCTV. One of the immediate considerations when an allegation comes to light is how to protect that victim in the short term. Immediate action that will help prevent them from being subject to any further behaviours, or perhaps a possible escalation of those behaviours too, needs to be considered. Ultimately, we want to and need to keep that employee safe in their working environment. To protect that employee, you might want to consider their daily tasks or their working hours, enabling them to work alongside more trusted individuals who can support them in their work when needed. However, we need to balance this reality very carefully to make sure that others aren't placed at a detriment and the employee isn't placed at a detriment for making a report of sexual harassment. At this point, you should start looking at your grievance and disciplinary policies and putting those into action. For example, to protect the employee making the report in the workplace, you may need to suspend the alleged harasser. Suspension should always be a last resort option and is considered where there are risks to the individual's safety and well-being, there are risks to the safety and well-being of other employees or clients, or there are risks to the business's reputation. And that risk can't be mitigated in any other way. If you are thinking suspension is needed, please seek HR advice at that point or at the earliest point that you possibly can.
Thanks, Katie. That's some brilliant advice. And it might also be that after discussing a potential incident of sexual harassment, the individual doesn't want to raise this as a grievance. If they don't want to, that's okay, but you still have a duty as a business to protect that individual and initiate an investigation via your disciplinary procedure. Or if there's insufficient evidence at that point, start to collate some evidence as part of a fact find. The individual might also want to stay anonymous, or you might have a witness who doesn't want to be named. In these situations, a careful balance is needed so that you can consider the impact on all employees. Encouraging anyone with line management responsibility to take advice from HR can be a really useful way of making sure that there's no well-meaning but misplaced actions being taken. The investigation process itself would be similar to any other workplace disciplinary investigation. However, there are some pointers that you might want to consider when dealing with a specific allegation of sexual harassment. Firstly, given how distressing that allegation may be for everyone involved, it's crucial that there's no delays in that process and that the facts are gathered as soon as reasonably practical, and that also any recommendations or action required is taken at the earliest opportunity so that the parties involved can move forward. Another consideration might be where you conduct the interviews. Can these be held somewhere more private and away from other employees? If you're a business with multiple sites, can you do those interviews at a different site so other employees aren't noticing that at all? Speaking of keeping it private, it's a really good idea to discuss with all parties at the outset that any information discussed within their witness or their investigation meeting is to be kept strictly confidential and not shared with anyone beyond that meeting. Ultimately, in these situations, preparation is key. And before starting the investigation, it's always a good idea to have a clear understanding of what the allegations are and therefore what needs to be investigated, what facts need to be established, what evidence needs to be collected, and who needs to be spoken to as part of that. You should also have a think about who's going to be an appropriate investigation manager in the circumstances. Firstly, you need to be confident that they're able to be impartial and that they're also unlikely to be influenced by the people involved in the situation. There shouldn't be any conflict or of interest or pre-existing relationship with either party, and they should ideally be trained and experienced to be able to conduct an investigation of this nature. Ultimately, that investigation is a fact-finding exercise to try and find out the truth of what's happened. So it's important that the appointed investigating manager is able to keep an open mind, not assume blame, and they also need to be someone who will be respectful to all parties. When you're thinking about those managers, also have a think about the seniority of your managers and the role they should take in the potential disciplinary process. For example, if you only have 3 suitable managers available, the most junior manager should take on the role of investigation manager, with the most senior manager then being on standby in case disciplinary sanctions are implemented and an appeal is received. In any formal meeting, we'd always recommend that you have a note taker in that meeting with you. That's going to allow the manager holding the meeting to concentrate on asking the questions and to focus firmly on the employee's answers. However, the note taker doesn't need to be another member of management if you're running short of suitable people there. As long as that individual has clear, legible writing, is impartial to the complaint, for example, they're not a witness, and is fully aware of the confidentiality of the disciplinary investigation process and that process as it goes on, you can utilise them as well. If they've had experience as a note taker before, that's going to help you even more. It's also important to remember that a poor investigation doesn't just impact the person reporting the issues. It can also severely impact the person who is the subject of the claim. We've seen a recent tribunal claim which was finalised in March of this year, where a former executive at William Hill has been awarded nearly £70,000 after they found he was unfairly dismissed over a sexual harassment allegation. The individual was accused of touching a female colleague inappropriately whilst at a pub where people were watching a Euros 2024 football match. The Employment Tribunal, in their judgment, criticised the extent of the company's investigation, lack of effort to secure CCTV footage, and also that the police had found no evidence for the alleged assault. What this demonstrates is that getting the right evidence at the outset will help to protect everyone involved in that situation. It's also really important for us to think about the impact of the investigations on managers, as these matters can be sensitive and really distressing for them to deal with as well personally. So where possible, try and make sure that managers aren't dealing with similar cases on a repeated basis, and make sure that they always have access to any wellbeing support that you have or are able to provide, or if you've got mental health first aiders on site, that they have access to them as well.
Thank you, Sarah. Yeah, that's some really great things to bear in mind. And thank you to you, Katie, as well. This has all been really, really good advice, and I hope everyone watching agrees with me there. But thank you for sharing your thoughts with us today. That does bring us to a close in terms of the content side of things. But we do, however, still have some time to answer a few of your questions live, which I've been picking out throughout the session. So we're going to answer a couple of them now before we end the session in a few moments' time. And first, a question that I have is for you, Katie. And this is, how do you deal with vexatious complaints if there cannot be any recriminations on complainants?
Right, thank you. So when dealing with complaints of sexual harassment, you should always remember that it's judged from the employee's perspective and whether or not they feel that the reported behaviour has violated their dignity and or created a hostile, intimidating, degrading, humiliating or offensive environment for them. Following an investigation, although the investigating manager may feel that it was vexatious, the employee may still feel that their concerns were genuine. If you feel that there's no case to answer following an investigation, we recommend that you contact the advice line to discuss those specific findings. We can then discuss with you how that you can make sure that any miscommunications in behaviour are remedied going forward.
Thank you, Katie. Next question I've got is for you, Sarah. So this one is, do you have a risk assessment template that you could recommend for us to use?
Yeah, so every business is different. So there isn't going to be a one-size-fits-all template for conducting risk assessments. However, I think to help support you and your particular business needs, when thinking about the risks of sexual harassment occurring in the workplace, have a think about some of the following. So what types of work do your employees undertake? Are they all based on site, or do you have a lot of employees who work remotely? Also, if you've got employees who are customer facing, is that on site or is it out on external events as well? Do any of your employees work in shift patterns? For example, night shifts where there might be less managers around to seek support from. I was having a chat with some colleagues the other day about kind of night shifts and what are the risks if, say, you're a manager on shift, you've got somebody with you and they've missed their last bus home. What are the implications of offering them a lift on that front? So build things like that into your risk assessment as well. Also, you've got to have a think, as we mentioned earlier, what the demographic of your workforce is. For example, if you've got some of those younger individuals in the team who might be less likely to report instances, have you got anyone with disabilities that might be adversely impacted? Or is there anyone within your team who represents part of the LGBTQ+ community? You also need to think about how your employees are employed on that front. Do you have a lot of agency workers or individuals on 0 hours contracts? How many different people have you got interacting at any one point there? I think ultimately we always need to remember, especially in this day and age, that workplaces are always changing, and you might want to consider almost re-asking those questions as a team at regular intervals, for example, every 6 months, just to make sure that you're supporting your employees and that your knowledge base there is really current.
Perfect, thank you. There is another one just come in as well. This one is sexual harassment always considered gross misconduct? Sarah, do you want to take that one?
Yeah, absolutely. So that is a really interesting question, and I would probably say whenever you've got an allegation of sexual harassment and you think, actually, okay, we've done the investigation, we feel that there is a case to answer, or we need to take that to a disciplinary meeting, do always seek HR advice at that point. The reason I say that is we need to treat each and every allegation independently. And you might have had, say, a set of sexual harassment incidents in the past, like you've classed as gross misconduct, and you're thinking, I'm not too sure about this one. So by getting that predominant HR advice, you can decide whether or not it is gross misconduct. I'd probably say if you are looking at allegations of sexual harassment, it's really important to ask those kind of questions in that who, what, where, why, how that Katie mentioned earlier. What is the impact on the individuals and those people around them? And also, what are the risks to the business? And then feed it all in and say, actually, how detrimental and how potentially dangerous is this for everybody involved in that situation? But yeah, it's definitely a consideration, but do look at each allegation on its own merits.
Great advice, thank you. And then last one I think we'll have time for before I kind of close off the session. So this one is, you've mentioned some great ideas as to what we can do as a business to prevent sexual harassment, but what can I do as an individual to ensure my accountability?
Yeah, absolutely. So as we mentioned earlier, sexual harassment can happen to anyone and anyone can be a witness to it. So even if you spend a large portion of your working day at a desk and facing a screen, you're still the eyes and ears of your business. So it's really important that you keep an eye out for, say, any inappropriate comments made on your team's groups chats or on any WhatsApp groups if you use them. If you're out and about, either kind of on the shop floor or at third-party events, check in with your team regularly to make sure that they're comfortable and if they've got any concerns. So you've got that open door policy no matter where you are. If you see any inappropriate kind of out when you're at work or at work events, you should always call it out, but in a really calm and professional way. For example, you could use a calm and a patient tone that you can direct the individuals involved in other directions. For example, asking them to complete tasks in different areas. And also at that point, make a note of any other witnesses that might be around before completing wellbeing checks with the individuals involved. Ultimately, we're all champions and leaders in setting the best examples for our team's behaviours. So although even things like that might sound like small steps, they will hopefully have a long-lasting impact and add value to your colleagues' wellbeing in the workplace.
Great, thank you. And thanks everyone for sending in those questions too. Just a reminder, if we weren't able to cover off your question today, we will be following up with you personally after the session. So keep an eye on your inbox there and the experts will have some great advice coming through for you. But yeah, we hope that you have found it a really valuable session today. Just a couple of things to cover before we finish. Firstly, I just want to say we're leaving the webinar open about another 5 minutes or so. So if you haven't downloaded the handout yet, I'd definitely recommend getting that downloaded. Again, that'll have all of the slides that we've gone through today and all of that information and those proposed changes that we've talked about as well. If you would like any help with anything that we've covered, please feel free to check out the Sage HR Advice portal. And with that, if you are a professional or premium customer, don't hesitate to call the advice line as well. And one of our consultants will be able to help you with anything that we've kind of talked about today. Now, a couple more things in relation to HR Advice and Sage HR too. Sage HR Advice, of course, is here to help you navigate and simplify all of these proposed changes mentioned. It also includes a digital e-learn library, and that's constantly updated with new content. Lots of additional resources and also toolkits for you as well. We do actually have one specifically on today's topics on preventing sexual harassment, so please do take a look at that. And then alongside this is also Sage HR. So this is where you can automate and simplify different tasks, loads of different HR tasks on there, and really, really customize things to suit your company and how your company works. We do actually already have some webinar recordings of some of those different modules of Sage HR. So if you are interested in knowing more about them, you can watch those at sage.co.uk/webinars. I would highly recommend getting more information on these products if it does sound like something that you would benefit from. And yet, shortly I will be launching a poll on your screen, and you can respond to that if you wish, and if you are happy to be contacted with more information. And then lastly, we do run regular webinars every week on Sage 50 Payroll, Sage 50 Accounts, Sage HR, etc. I do also want to mention at this point our next webinar in partnership with Advisor Plus. So that one is going to be real scenarios, real advice, and that is scheduled for Wednesday the 6th of August at 11 AM. So for those of you who have downloaded the handout, there is links to click on this slide just to sign up for these sessions, whether that's the ones for payroll at the top there, or that next Advisor Plus session too. But again, you can always find those upcoming webinars at sage.co.uk/webinars. But yeah, with that being said, that does bring us to a close today. Thank you so much for your time. And as I say, we will be following up on any unanswered questions too. The last thing from us, you will see a short survey as you exit the webinar. So if you do have just a moment to fill that out or any comments to leave us from today, we would really, really appreciate that. We do read every comment just to help improve the webinars going forward. But thank you again to everyone joining us today, and massive thank you to Katie and Sarah as well. You've both been brilliant today. We'd love to see you on another webinar very soon, but from all of us, it is goodbye for now.